goals and objectives, then each subsequent plan adds a few more and reviews them and says this one's valid, this one's not valid. Oh, by the way, here's another list of goals and objectives to add. So if you look at the 2013 plan right now, I think the list of goals and objectives is somewhere in the range of 10 to 12 pages long, which is probably way too long considering half of those goals and objectives essentially say the same thing. And that's what, like we talked about last time, the primary goal that I really want to make sure is the focus and the emphasis of this plan, that somebody reading through the plan, the takeaway would be Franklin Township wants to preserve its rural character. And then there's listed, of course, the sub-goals and objectives on how you would achieve that. But that being the primary directive of what we're trying to do and what the town is trying to accomplish through the master plan and then through subsequent zoning ordinance revisions over the past 10 to 15 years or so. So I consolidated the goals. I kept it in the same general format, which is not necessarily common, but I think it's okay. Having an assumption and then a goal and then individual objectives towards that goal. So each goal is sort of how we want to address what the issue is raised by that assumption. The first assumption I reworded slightly. The previous plan had said that there would be pressure for development and growth. And I reworded that to make it clear that right now there is not a lot of pressure for growth in Franklin. However, in the event that someday in the future somebody does extend sewer service into the township, then you probably will experience tremendous growth pressure. So just to make it clear that you do need to plan for some growth, and to a large extent the town had been doing that. But that growth isn't going to occur unless there's water or sewer. You're not going to get a 500 unit or 1,000 unit mega development coming in without water or sewer to support it. And that is really reflected in the data that's in the other parts of the plan, where the township's growth in terms of population has been kind of stagnant, very little growth. I think you grew a lot in the 60s and 70s and a good bit in the 90s, but since the 1990 census counts, you've I think grown by about 1,500 people in the past 30 years. I do try and explain in another section of the document, because DVRPC, the Regional Planning Commission that is tasked with providing population projections for everywhere in the Philadelphia region, both in Pennsylvania and southern New Jersey, I think they project a 5,000 or 6,000 person increase in Franklin Township in the next 20 years. That's very unrealistic. Even if you had water and sewer extended, I don't know that you would grow that much in the next 20 years. And in the housing plan, we explained that, as well as in this, I basically use the same explanation. That seems very unrealistic. But anyway, primary assumption is that you're going to experience growth pressure if water and sewer are extended into the town. Without water and sewer being extended, it's really a bit of a moot issue. You're going to grow the same way you've been growing for the past 30 years, which is a very small piecemeal subdivisions at a time, a handful of 5 or 6 unit developments and small strip malls here and there, and maybe a few industrial projects. And then so I have the goals and objectives there are largely the same as they were before, just consolidated, where instead of mentioning that you want cluster subdivisions and protection of open space and protection of historic resources, 4 or 5 different ways and different goals, I try and just state that one time and state it clearly. Next assumption is pretty similar to what it was in the previous plan, with the policies at the state, county, and regional levels, which is largely the state development and redevelopment plan. They're going to stay the same in that they're going to encourage wherever you are going to grow to be within what the state plan calls planning area 1 and 2, which coincides with your sewer service area generally on the map. And the state plan will discourage growth in areas outside of those, which are the areas they deem environmentally sensitive. So we're assuming that's not really going to change. The state is redoing their plan right now, and my expectation is they'll have some sort of draft or a new plan maybe by the end of the year, but it's probably going to be the same thing in terms of the mapping of where they would permit sewer service and where they would not permit sewer service. So the assumption is that is going to stay the same, and that your goals and objectives there are just to make sure that your land use policies are consistent with that of the state and the county, so that you're not at odds in any legal way and finding yourselves in hot water with DEP or DOT or any other state agency. The third assumption, which is almost slightly contradictory to the first one where I said you're not going to be growing, but you will, I think, continue to be an attractive place to live. There will be people who want to live here, but opportunity is going to be limited in terms of, right now there's not a developer who's going to come in and build houses for those people because you don't have the infrastructure capacity to do so at this time. And so to meet that goal, simply just list of objectives, so kind of standard language here of making sure you provide for a variety of housing types to meet people of different income levels and different abilities. And largely, anything legally speaking regarding allowing people to live here, you are now covered by the housing plan, which has been fully certified by the court as of last week. You are, at least until next year, immune from any builder's remedy lawsuit, and then we get the new round of affordable housing coming out just next year, or actually really at the end of this year, you have to start the process. Fourth assumption is that as any development does occur, this doesn't have to be massive growth for residences, your transportation infrastructure might need to be upgraded. So this would be largely making sure you have appropriate road improvements as needed, and that you coordinate your road improvements program with anywhere you're expected to grow or anywhere newer projects are coming in. As well as, to the extent you can, making sure that you're encouraging and promoting alternative modes of transportation, whether it's walking, biking, use of electric vehicles, to the extent that you can promote that at the township level. Fifth assumption, the township's going to continue to seek to diversify and expand its economy. Obviously the town, on some levels, wants to see economic growth. You want to have jobs, you want to have tax dollars flowing. So you need to strike a balance between this preserving the rural character, but also making sure there's opportunities for some business development, both for existing businesses and for new businesses to move in. And I've generally organized these objectives to be consistent with what we've said elsewhere, in that, sure, you do want to accommodate job growth and economic growth and attracting ratables, and making sure those types of businesses are in appropriate locations as close as they are to existing infrastructure, in particular the highways. And doing so in a way that you're attracting growth while still maintaining the rural character of the township. That's one thing I tried to emphasize in a lot of these points, is that your objective is, yes, there's sometimes contradictory or conflicting interests. Usually economic development and historic preservation, or economic development and open space preservation, if you have different departments in the township, they're usually at odds, because the economic development people want to see everything developed to bring in jobs and tax dollars, while the preservation people want to see nothing developed because they don't want anything to change. So you want to strike a balance between the two and identify appropriate locations for the economic development and preserve elsewhere as much as you can. I've tried to make sure that's iterated to some degree in each of these goals and objectives, that gets the point across that we're pro-economic development, but as long as it's respectful of the rural character of the town and not destroying all the open space you have and eating up all of your farmland.
That should be our mission statement.
If you want it to be the mission statement, we can put that on the cover of the plan. It's on its face by itself, it's a very, very obvious statement, but what it comes down to when you actually start getting applications for development in, and we look at the zoning map and where are those appropriate lands. Because to some degree, the goals and objectives are kind of statements, obvious statements of, yes, we want to see good things happen, we want to avoid bad things from happening, but then when you get down to the details, is where they get a little bit more confusing, a little bit dicier. But the good thing is, this is a master plan re-examination. We're not rezoning the entire town, we're not redrawing the entire zoning map, we're rewriting a list of permitted uses in every single district here. We're looking to see anywhere in your current ordinances, where would we need to make changes to effectuate some of these plan and policy statements, which, as I'm going through these, they're largely the same goals and objectives as you've had at least since 2004 or 2007. I've just restated them in a way that I think is a little more clear and concise, without avoiding being redundant or repetitive in some of these goals. The sixth assumption is about protecting water resources, that as you're going to continue to rely on wells rather than a public water utility and a public sewer utility, that safeguarding drinking water and water quality should be a top priority for the town. The next assumption, this was in the 2013 plan, but not the previous ones, discusses alternative and renewable energy sources such as wind and solar. And there's an assumption that those are going to be, that's going to be across the region a growth industry. But again, we want to make sure that anywhere that those facilities do come into town, that they're respectful of the rural character. So the 2013 re-exam had several statements to the effect of wanting to safeguard from the visual impacts of large commercial solar utilities or wind farm. Or I don't want to use the term, because the 2013 plan specifically says Franklin Township does not recognize a solar farm or wind farm as a farm. It's not an agricultural use. It's an industrial use. But allowing them in appropriate locations and recognizing that there is a need for alternative energy, and it's gonna be a growing industry, but wanting to have safeguards in place so that they don't, it's not a massive disruption of the image of the town as a rural
We
place.
can do that through the zone.
Yeah, now, all these goals will be, the actual meat of anything that has any legal standing gets done through the zoning. So in the plan, we're not necessarily rewriting any zoning. I mean, we can get to whatever level of detail the committee or the planning board wants in terms of where we're rewriting anything, but there's no requirement that we literally have to rewrite, say, change section 253-65 for sub-bullet A, little bullet, little 2, and then we're rewriting things. We're making some recommendations, and to the extent you want to get to any level of getting into the weeds, we don't necessarily need to. And then it's once this plan is adopted, it'd be up to the township committee to review it and determine whether or not they want to go forward and make any additional changes to the zoning. There is that separation of powers. So the planning board adopts the master plan, and the zoning ordinance, which is adopted by the township committee, is required to be consistent with the master plan. But the township committee doesn't have to follow every word that the planning board says to a T. They're allowed to adopt ordinances even if the planning board says it's contradictory to the master plan, so long as they provide their reasons on the record for doing so. So there's always not necessarily tension, but the zoning ordinance doesn't necessarily need to follow the master plan word for word, which is one of the reasons why the master plan doesn't need to spell out what you want to see in the zoning ordinance word for word. I wouldn't necessarily recommend going that far in a re-examination report, at least not for everything that's in here. For a few things, we do make some recommendations where there are specific issues, and we can make some suggestions there. But anyway, the point being that the purpose of the master plan is to really set the stage for what your zoning is, because by law, as I said, the zoning has to be consistent with the master plan. If you don't have a valid or recent master plan, the zoning is not considered to be really a document serving the public interest, because it's not connected to a publicly conducted planning effort to decide what the vision and goals for the town are. So the master plan basically states in a general sense the 30,000 feet above view of how you want to grow, or where you want to grow, or how you don't want to grow, what you want to protect, what you want to see change in town, what you don't want to see change. And then the zoning ordinance is supposed to be set up to reflect those wishes to the extent that we legally can permit and prohibit certain things from happening. Okay. And that's okay. Okay, sorry. No, not missing face. Yeah, so that's really it for the reorganization of the assumptions and goals and objectives. I don't know if any of you have any comments on those or questions about it?
Is this the place where we can just add one word?
Sure.
In the first goal, promote the preservation of contiguous open space, which doesn't mean that it always has to be, but that, I think, should be a priority. Just adding that one word in the first one.
H1, goal 1,
Just put it-
objective A.
Contiguous, promote the preservation of contiguous open space. Yeah, and I'm fine with that. And I also got the list of preliminary recreation open space inventory recommendations. I believe it was you that sent that.
No,
Oh, it wasn't,
it
that
might have
was-
been Suzanne or.
Yeah,
Somebody sent that.
it's up on the website.
Okay. And I'll get to that in a minute, but the more of the specifics of exactly how and where you want to preserve open space, I think would probably be more appropriate for an actual open space and recreation
Right,
plan,
yeah.
which the township is due for. But certainly, yeah, if you want me to add a word or two in here, feel
I
free.
mean, I
to
just think
mention
that that's very important, that that's like a guiding principle, that while not all open space can be contiguous, that if it can be, that should be given.
It functions much better if you have 100 acres of contiguous open space rather than 10-acre parcels that are completely isolated. There's greater benefits to contiguous open space, yes.
I mean, maybe you can state that, preservation of open space with an emphasis on contiguous, because we want to promote both, right? Contiguous and non-contiguous.
Right.
Yeah, I've got no problem with that. Okay, well, that's,
Do you want Number 7, assumption 7 has to do with energy sources, and, but it also goes on, oh, am I missing a page? Where's the line? Doesn't it jump from page 4 to page 5? Where's number 1 on this?
One is the first, all of it.
Oh, all of
Yes,
it.
that's literally what I was just getting, using my cell phone. I jumped to the next page and I saw number 2 at the top. I was like, wait a minute, but number 1 is the entire list of
That's right,
violations.
and I think before that, okay. So number 2 and 3 and 4 and 5, oh, they're all ordinance no.
Well, yeah, the way I've kind of organized this, the recommendations 1 through 5 are more planning recommendations, that wouldn't be ordinance changes.
Right.
So this is saying the township's due for an open space and recreation plan. The third, I think, an environmental resource inventory to accompany the open space and recreation plan would make a lot of sense.
Yes.
The fourth, historic preservation plan element would also be a good idea, since we're on this topic of preservation, that it's not only environmental preservation, but also cultural preservation, which is what the historic preservation plan would do. And then the fifth would be that you, to the same goal, you just adopted a couple of years ago a new farmland preservation plan that emphasizing the need, really need to make sure you stay on that and try to implement that as much as you can. That plan has a lot of recommendations in terms of where you're targeting farms for preservation and what, where the important soils are and where and why you're going to target farms for
Yeah, some
preservation.
farm should not be labeled farm.
Farm.
And supporting
Well,
the
that's right.
farming industry in whatever way as well is an important part of the farmland plan. It always was.
Supporting industries.
And kind of recognizing farming as a major industry for the township.
Okay, and I did try and state that.
Yeah, you did.
In the economic objectives, that not just, economic development doesn't necessarily just mean, jobs and light industry, but also supporting the industry you have, which agriculture is one of the biggest ones in town.
We were sort of wondering if it would make sense, as we go through the ordinance recommendations, to break them up and concentrate on
Sure.
them in sets. And obviously, we would need more meetings in order to do that. But for example, number 6 through, well, maybe 11, are things that we could talk about in some detail tonight, and if need be, devote the next meeting to the difficult topics, which are warehouses and cannabis facility businesses. And then the last group, it would almost cover everything else, possibly.
Yeah, if that's what you guys want to do, then certainly.
Sounds like a
I
plan.
mean, unless we want to be here until,
No.
go through everything.
That's up to you guys. So, all right, so
Let's go at it.
the 6, which
6 to 11.
I'll start with number 6, and this is, I'm not even sure that we need to have this in the plan, because whatever happens in court will kind of take care of that. The township did in, what was it, I don't want to say ordinance 11, 12, and 13 of 2022, maybe it was, and then a subsequent, maybe ordinance 19, so I'm forgetting the exact numbers off the top of my head. There's 3 different solar ordinances that got adopted, one of which replaced the first one. And those ordinances regarding solar, my understanding is that the same applicant who wants to put up the solar facility had challenged those ordinances going on at the same time as this application that's been filed for a site plan. They've also challenged the ordinances as a whole. They don't technically apply to that site plan. So depending on what the courts say about those ordinances, you may or may not need to make some revisions to those. So since that's still pending in court right now, I think, I don't know that we need to say anything there, but it's something we might need to be conscious of.
I think
Yeah.
it's
Right, so,
overall.
since that's still pending, in court, we don't really know where it's going or where it's headed at this point. I think it's just better if we just skip over 6. I think there is some discussion that potentially would need to take place, but given the fact that we're not sure where the court's gonna go with it, let's just see what the court, because there has been a challenge to whatever has been passed, had been already put in place, so. From what I understand, there should be some kind of resolution in about August of this year. That's what I hear. Briefs were filed not too long ago, so. Well, that's okay.
Let me ask you something. how does the town protect itself in the interim from then until August?
Well, right now you've got ordinances that are on the books.
There's-
And they challenge the same.
So there's, right, without going into too much of, you know, this is unfortunately when there's a litigation going on, there's not only so much that can be said. Certainly, just by ethically and also just to protect the town also, in that instance, as well. So there's ordinances in place, and if there is another, I guess you're saying if there's another challenge in
Yeah,
the
because
interim?
I'm a planning board member, but I'm talking about what we have on number 6. I could talk about that, right? And I'm just saying, if another application comes before us, before August, if
Before
we
there's
have
a
to ruling.
resolution, you're saying, before there's, I mean, so you have an ordinance in place, and that's how you would, and that's how
Typically,
you
you would be rushing to the, to be
and that's
rushing
how
to
you
the
would
zoning board.
decide, yeah,
to get,
unfortunately, you know, that's,
get in.
at this point, the ordinance that's in place is the ordinance that that governs at this time, so that's what we would look at. And you, facilitating your duties as a planning board member, or whatever the case is, you would look at the ordinance that's in place now, and that's what would govern
Yeah.
your action.
The same for
The
this.
other thing I want to point out there, the ordinance has been challenged, but off the top of my head, I don't know exactly what the challenge was, if the challenger said the entire ordinance needs to be scrapped, or they challenge one particular provision of the ordinance. Now, all the ordinances have that clause at the end that say, you know, any statement or paragraph in here is deemed to be invalid, that should not invalidate the rest of it. I mean, there's a lot in there. Those ordinances regulate accessory use, solar, if you want to put solar on your roof, you want to put solar in your backyard or your homes, to commercial solar. So there's a lot in there. But it could very well be that a judge says it's all fine, or says, okay, this one paragraph, we got to change that. So honestly, even though I put this in here, my recommendation probably we just take this out of the plan for now, because if a judge says you got to change it, then you'll change it. If the judge says you don't have to change it, then it's going to stay.
There is a however, if we think we're too loose with our ordinances, and we think we should tighten them up for any future applicants, now's the time to do that.
Yes, and
That's what
I think I have that. Did I put that elsewhere?
Well, just to make a comment, I think we're actually not too loose, we're too restrictive in certain instances, not too loose. I mean, it's a shame that they've blended those two ordinances together to deal with like a large scale utility as well as the, you know, residential accessory. So I don't know if we could bifurcate those, or.
Yes, actually, I do have to apologize. I thought I had put that in here, but I did not. In my notes that I had from the meeting last time, I did have that. First is that the current solar ordinance is being challenged. The second, there was a discussion last time, in particular the accessory solar, that maybe the ordinance that was adopted 2 years ago was a bit too restrictive with
Residential land.
The 50-foot, was it 50-foot
Buffer.
buffers that are required, and the
3 acre
maximum
lot
minimum lot
size.
size.
3 acre
of 3
minimum
acres.
lot size.
But if that's what this body wants to see in the plan, that we don't necessarily need to specifically say it needs to go down to 1 acre and 10-foot buffers on that level, but you can certainly put it in terms of, we think this is a little too restrictive, and if the goal is to encourage solar, then maybe the town committee should reconsider those restrictions, and it'd be up to them to determine.
Or scale the buffers based on the lot size.
Be the same thing as.
Large lot, minimum buffer. Small lot, large buffer.
Sure.
You know, to
That-
protect the
that-
neighbor.
I mean, couldn't we simply, in the definitions, change the definition from accessory solar, and segregate that from utility scale solar?
Oh,
And-
the ordinances already did that.
Yeah, I mean, I don't see why a accessory solar system on a residence should be any more restricted than what, any other accessory use would be, a shed or a pole barn or anything else. I mean, and there's really no buffering requirements, I don't believe,
No,
from
just the-
residential
just the
accessory uses
setback.
to other, yeah, I mean,
Not sure why they made them so big.
yeah, I don't know either why they.
And that's all within the past year, correct? That new ordinance?
Some-
It's
some-
2022. The summer of
Yeah,
2022, I think it was.
All right, year and a half.
They're recent, and that, these same points I do recall were brought up at both the planning board and the committee meetings when they were adopted. So, I mean, I can say the committee is certainly aware of these concerns, and they were brought up at public meetings, but if it's this subcommittee and then the larger planning board's wish, then they certainly can put it in the master plan, because it is your document, not their document, but you think they should reconsider those restrictions.
If we want to promote solar on a residential use end, then we need to make the laws more lenient.
I would not disagree with that.
I mean, I don't want to speculate on what was in the committee's mind at the time, but I would like to assume that they were focused on the utility scale piece of it, given what was happening within the community at the given time. I mean, 'cause I don't see anybody that would reasonably think that those type of restrictions should be applied to, somebody putting a, little ground mount system to service their home,
Is this the proper time then to dig into residential solar?
Sure, I mean, if we're only going through 6 through 11 tonight as the goal, then yeah, we might as well do that now.
I mean, I don't know what there's to dig into other than
Well,
basically
make
what
our
it said,
statements
yeah.
as far as the smaller the lot, again, our setbacks, and then the larger, because the current ordinance does state 3 acre minimum for a field array, whatever it's called, ground array. So if you live on an 1.5 acre lot today, you cannot get a ground array unless you apply for a variance.
Correct, yeah.
I think that's crazy.
I think, like I said, the restrictions for accessory solar should match any other accessory building on a residential
Agree with that.
lot.
Well, we're saying the same thing,
Yeah.
Yeah. Well, it keeps-
but we need to get it
keeps
in writing.
consistent.
Which raises a question that some reexamination reports, while I noticed that this is true in the 2013, I believe it's 2013, maybe it was the 2011, but anyway, some things are spelled out with a map, even showing some of the changes that were recommended that are in the master plan. And in the master plan itself, it specifies exactly what the changes should be for some zoning. I think it was 2011, and it has a map showing it. And I wondered if that is customary to do.
Yeah, a zoning change, I mean, if you already know exactly where you want the change to occur, then there's certainly no harm in including a map, so that there's no ambiguity when it goes to the committee, especially a zoning map change. They usually, so I've seen some reexamination reports that'll literally just say, reconsider the northern area of the town, look at the zoning, and no further instruction than that, so it's kind of a meaningless statement.
Right.
And then, yeah, you can get down to the level of literally this block, this lot is proposed to be changed from the RA to the, light industrial district, or whatever it might be, and that, then there's no ambiguity, and it's pretty easy for the township committee to look at that and say, yeah, we think that's fine, we'll go ahead and draft that ordinance, and then when you send it to the planning board reviews, it's a very easy step of saying, okay, our master plan said do exactly this to a T, therefore that process is simple. So for a zoning map change, I generally would fall on the side of being more specific rather than vague statements, yes.
Well, and even
Including
in
maps.
this issue about the solar homeowners being specific about what lot size you think, should there be a minimum lot size at all? Should there be, what should the setbacks be?
Capitalizing.
How specific do we want to be about that?
We don't have to say anything if we capitalize on what Jason said and say, let a ground solar array follow the same guidelines as if it were an accessory structure,
Sure.
period.
And if that's what you all want to say, then yeah, we can put that in the plan.
Yeah, not to open up a can of worms, but another section of our ordinance, which is very vague and may not even be in there, is the setbacks for an accessory structure.
Yeah,
So
50 feet.
one is, I thought they were all kind of, yeah, they followed the setbacks of the principal structure, correct? Like there's no reduction in any given zone for an accessory use, is there? Yeah, but they're segregated by primary structure, correct, not accessory? So-
No, your primary is all your accessories are separate.
Yeah,
I think-
3 acres, 15 foot.
I think
setback.
some of the zones in the town specifically say that accessory structures should be set back, 5 feet from a side yard, 10 feet from a rear yard, principal structure, but then there's other zones that might not have specific separation of principal structure versus accessory structure.
Right. I mean, I think that, what Chris is saying, I'm not aware of what you're saying. If it's in there, that's fine, but, like, most, you have a less restrictive setback on accessory use.
Yeah, that is customary.
Yeah, and I think we should make sure that that's correct.
Yeah, 'cause that's what it says 3 acre minimum.
Right. So like in the RAs then, like what's the accessory structure setback and where's that found? Do we have any idea? No, I didn't have.
It's in ordinance somewhere, I'm sure, but accessory under 600 square feet
Mhm.
is 15 from the side. Over 600 is 50 from the side, both are 50 milligrams.
And must be behind the residence.
That's for all of them, yes.
Right.
Yeah, I think that should be like, I mean,
Right.
you know,
I mean, there's different zones that are 10 feet,
right.
and it's, you also have lot sizes with that, minimum sizes.
Right.
So are we saying that it does or doesn't work to?
Well, I think,
Make reference to
I
the
think it should be a
sentence.
little bit more clear. I mean, I can do some further research on it, because it's not clear to me, at least when I read it. You know, I don't know if we want to talk about what that setback should be, but I think there should obviously be, you know, 50-foot rear setback for a shed or a solar array is a little restricted in my opinion. You know, I mean, for a principal structure, that might work, but, I know, you know, in the city of Island, I think it's like 6 feet for accessory structures. I don't know if we want to be that aggressive, you know, but, you know, 10 feet is, I don't think is unreasonable, but.
Would we like to set a minimum lot size for no solar array on the ground? Like a half-acre lot, be too small? Do we want to say that?
I don't think so, because, you
Could
know,
be just a small solar array.
yeah,
Okay.
if you could build a pole barn on a half-acre lot, and you can put it on the roof, why can't you just put it on the ground without the pole, you know what I mean?
As long as you meet the setbacks.
Right.
See why, because sometimes the roof isn't the right place because of trees and
Mhm.
all the rest. So putting it on the ground is an advantage. And it wouldn't be any bigger, certainly, than what you could get on the roof, so I don't see why it's a problem.
How did we get 3 acres to begin with?
Yeah.
Because it's solar panels shall be permitted as ground arrays in any residential zoning district in accordance with the following 3 acres, 50 feet from all property lines, not in the front yard, of course. So where did 3 acres come from? I mean, that's like a Pinelands,
Well, where the 50 feet comes from.
yeah.
So we're on agreement, we're changing it.
Yeah.
Yeah.
somehow.
Well, recommendation,
Yeah, recommendation.
recommendation.
Recommendation to
Right.
change it, yeah.
Okay, yeah, that was easy enough.
at least look into it, right?
Right.
And if we, a little more specific, I think, than just a recommendation to review, or in some cases, that's all
Well,
that you can do.
what I have in my notes here, and what I'll put in the next draft I'll send to you, is that the recommendation is that the treatment of accessory solar should be no different from any other accessory structure in its given zone in terms of setbacks and buffering requirements.
Mhm.
Essentially, the definition of accessory structure should include, you know, ground mount solar arrays, you know?
Right. Yeah, that's a good.
That's a
Well,
bigger,
I wouldn't recommend changing the definition itself, because the definition of accessory structure right now is just any structure on the lot that is not the principal structure.
Right.
So, this would just, all we're doing is suggesting that the committee revise the language about the setbacks, to just say accessory solar is permitted, provided that it meets all other setback and coverage requirements in the respective zone. I think that would cover it.
Yeah.
I don't think we need to change the definition to specifically say it includes accessory solar. No other specific accessory structure is, I think, mentioned in the definition of accessory structure, other than it might say such as garage, pole barn,
Right.
you know, pool house, yada, yada.
Okay.
check that one off.
Well, I think it seems done.
The next one I have in here, I think will be, I don't know how much more conversation will warrant, but is about what was discussed briefly last month, was about the battery energy storage system, which I had heard of before, but I had not really looked into it too much. So I honestly, I don't know what to say here in terms of, this is not something I've reviewed before where I can say, well, this is the way other towns have done it, or I've reviewed 5 of these things before, and this is how they usually come in. So I don't know if these are gonna be something that Atlantic City Electric is gonna wanna replace part of their substations with these. I honestly don't know. I'm not really a utilities expert in the sense of, like, I can say, they appear to be about the size of a shipping container, and it looks like you can put one of them on a lot, you can put 100 of them on a lot, depending on how much energy you want to store. Probably my suggestion would be to treat them when they're more than a handful of these things, that they're like almost like an energy substation, and that they be treated as some sort of utility infrastructure, and perhaps that they get treated in the same way that the solar is. I don't know if there's personal versions of these things, or somebody's gonna put a battery energy storage container on their own property. But certainly if somebody's gonna come in to put in 100 of these things, it's gonna be some sort of larger energy company. They should probably be treated the same way that the utility scale solar is treated, in that they're,
We know of any,
I was gonna say, would you like me to look into
Yeah,
whether
definitely.
other towns
I
have how
think,
they
yeah, I
do
think you
it?
can do personal ones from the article that I had scanned. It's, they can be little and they can be
What I can do
just
is,
really big.
I'll look into whether other towns have dealt with that and see if I can find any ordinances that deal with that for next
sure.
meeting.
I know that the article had pointed out that some of them are gonna be in somebody's garage where they're charging their electric car, is part of what that is, and then other ones were of the size of a shipping container, and you got 10 of them next to each other on a big concrete pad, where the impacts would be no different than an electrical substation, where it's basically a utility use. Not the most attractive utility use, I'll say.
I'm just thinking so we don't get blindsided by it. You know,
No,
with all
certainly.
the solar and wind, the storage is gonna become a thing, so.
And this again is something where we don't necessarily need to get into the weeds of telling the committee exactly how or where to permit them, but just making sure they're aware that this is something that you might see someday in the future. And if you have, like we've discovered with some other things, if you don't have an ordinance on your books saying how or where you want something to happen, then whatever some other larger law is in place might overtake. Although I don't think, there's no state laws on these right now. There is state law for wind and solar, but I don't think this would be considered renewable energy the same way wind and solar is. It would be under that same law that permits solar facilities on 20 acres or greater in an industrial district. But you never know. There might be another law signed in a couple of months permitting these. Okay, the next one. We had talked about this a little bit. The RA district, I think, should be simplified a little bit. Really to separate the difference between a major subdivision, which if you look at the RA district standards, there's like 5 or 6 pages of discussion on the different conservation or cluster subdivision options for major subdivisions and all the things prior to those. But every application we've seen, either the planning board or the zoning board, at least in the 5 years I've been here in the RA district, has been a minor subdivision or somebody looking to develop on an existing lot with no subdivision. And the RA district is a little unclear on what is supposed to apply there, although there is a footnote to the ordinance that says when the ordinance was adopted for the RA district, existing lots are supposed to be permitted to develop under the previous standards of the R2 and R3 district, well, what was there before. But no one really has the R2 and R3 district standards anymore. It's not in your current code.
I told you I had it, I brought it.
Yes. It's in a paper copy somewhere. But the recommendation here, I think, is that be simplified instead of referencing an old code, whether it's those standards from that old code or inserted, or something a little simpler of a new set of standards for undersized lots or existing lots. It simply says instead of a 1.5 acre minimum, maybe it's, whatever the existing lot is. There's quite a few 1 acre and 3/4 acre lots out there in the RI district that they're permitted to develop under something very similar to what the standards of the R2 and R3 districts were, provided that they're not proposing a major subdivision of any kind, or any kind of subdivision really. And we spell out specifically, here's the front, side, and rear yard setbacks, here's the max building coverage, rather than just referencing an old section of the code that apparently only Jason has.
Yeah. I brought it to share with you tonight. That's what
I'd like to see it.
I had printed out, and I should have brought it and shared it with the rest of the board, but I had printed out and given to Ralph
Yeah.
a copy of
Vineland.
Vineland's ordinance section on this. And, just for a little bit of background, I've built in quite a few towns, and Steve can probably attest to this. So I've read a lot of different towns, non-conforming pre-existing lot ordinances, and the ordinance in Vineland seems to work very well. It's been in place for at least 20 years in Vineland, and it's probably one of the better ones that I've seen. And essentially, we would have to, if we decided to adopt something similar, we would have to tweak it because of our situation we have with the RA district. But in essence, their ordinance states that any lot can be used for any purpose permitted in the zone on the smallest lot, so long as all of the bulk standards are met, meaning front, side, and rear yards. So regardless of your lot size, your lot frontage, so long as you meet those requirements in whatever particular zoning district you're in, you are able to develop it without, going from for a variance. So, I guess the idea being that regardless of your lot size or frontage, if you had a 100-acre lot or a quarter-acre lot, you can still build the same distance from your property, your neighbor, you know what I mean? So
The only thing there that I would say, where I would personally like to see actual standards put in, is because the RA district, the minimum lot size right now is 1.5 acres, so approximately 60,000 square feet. But if somebody has a lot, an existing lot, let's say, 28,000 square feet, the standards for that 1.5 acre lot, now your building envelope is a lot smaller, and they're likely to need front side or rear yard setback variances.
Right, I mean, to that point, that was the section where I said we'd have to kind of get creative with the RA section. And if you go back and you look at the old RA, the old R1, R2, R3, the predominant setback was 40 feet front, 15-foot side, and 40-foot rear, which is not really a gross difference from what we currently have, under the RA district, which is 75-foot front, 20-foot sides, and 50-foot rear. So, and the issue being, there's quite a few developments in town. That was from the 1984 master plan that those districts were put in place. But prior to that, there's several larger developments that were done, in the 60s and 70s, which many of them have, 100 by 150-foot lots. So, I think, if you put something along that 40 to 50-foot front yard setback, 15-foot side yard setback, and a 40 to 50-foot rear yard setback, that would cover a very good majority of these lots that were, the Newfield Terrace area. I know you're probably not familiar with it, but people here should be. The Oak Avenue area, a lot of those lots, were developed in the 60s, and those are the ones that would be problematic, moving forward if we didn't address this situation.
To piggyback on that a little bit, the 2004 master plan, we did away with the 1 acre lots, and we went to a 1.5 acre minimum for a minor subdivision and a 2.5 acre minimum for a major subdivision. I have noticed by attending different zoning board meetings that there are many residents that now live on a 1 acre lot that 15 years ago, 20 years ago, was a lot. And today it's not. And our boards, our zoning officer, have required these people to come in and obtain a variance if they wanted to add on to their structure. And I don't think that's right. And I don't know what language we can incorporate.
I think that existing non-conforming lot language would,
Exactly.
essentially, we have it for every district outside the RA district. You already have your setbacks in place under the ordinance. The RA is the one that's real vague that we're trying to correct, so we could say if you have an existing lot in the RA zone, as it sits today, then
No variance required.
no variance required regardless of,
But we need that language.
so long as you meet these setbacks. And
Setbacks.
that's what we're talking about.
The building envelope is there for them to build.
Right.
If they can't build, well, then they can't build.
Well, in that case,
Yeah,
then
consistent too.
you come to a
Kinda
board.
cleans
then-
it up.
Yeah, and you ask for a variance at that point, you know what I mean? But-
Well, I honestly think you can do both. You can have language that says, basically, for any existing lot, there's no minimum lot area. But new lots, newly created lots would have to meet that 1.5 acre minimum. But in any existing lot, there's no minimum lot width, no minimum lot area, no minimum lot frontage required, because it's an existing lot, you can't zone somebody's property to any utility, you can't build something. Then you can say that if they otherwise meet all the bulk standards, then, no zoning is required. They go straight to getting their building permit, assuming they don't need the setback variances. But you can also have a provision that indicates for existing undersized lots that there is some provision of reductions in the required setbacks. If you have a 25,000 square foot lot with a 75-foot front yard setback, might be more than necessary, especially if there's conditions where every house around you has a 40-foot setback and you're being required to go back to 75. There are a lot of towns, and it's always a little difficult to measure these, but what's known as the prevailing setback, where usually for a front yard is where this applies. You'll see plenty of places where, say the standard development in a little bit more urban area was a 50-foot wide by 100-foot deep lot, so 5,000 square feet. And it was pretty common that, the house would be built, say, 20 feet back from the right of way, little front yard, they're pretty consistent across the front. And there's 2 or 3 blocks of that. And then the new ordinance comes in and says you got, 10,000 square foot minimum lot size with a 60 or 70 foot front yard setback. And somebody comes in and says, I'm just looking to build a house that's pretty similar to what all of my neighbors on each side of me have, and they have to get variances for that. So you have what they call the prevailing setback, where if you can demonstrate that most of the other houses or the other buildings on your block or on your street are in violation of this section of the code, then whatever that line is where they all meet is what your front yard setback is, rather than whatever it says in the code. It's difficult to measure that unless you have all the houses are literally 20 feet across, which I don't think there's many places in Franklin where every house is exactly the same setback, with the exception of the handful of developments that were built at the same time as larger developments.
I mean, I would just throw out a suggestion that, we look at the most restrictive, or would be the most or least restrictive, and the old the old residential districts, and we use that, apply that. I mean, because that's been in place since 1984, so, which I believe is 40 foot front, 40 rear,
And we can-
15 sides.
We can definitely do that. As my suggestion would be, instead of saying
Unless
the
they're
old
different.
R2 district standards, we literally codify those standards again, so they're actually in the code.
And there, yeah. I mean, unless anybody wants to suggest a reduction from that, I mean, I don't.
Now,
Yeah. I mean, I've built on a lot of 100 by 150 foot lots, and, a 40 or 50 foot front yard with 15 foot side, it gives you a nice size envelope, you know what I mean? So,
on this topic, I've seen it in the past at planning board meetings, that the word minor and the word major gets a little crazy and gray. And we go by the standard that you can divide up to 4 and it's a minor. As soon as you hit the 5th, it's a major. Well, I've had attorneys representing clients come in here and apply for a major on a 4 because they didn't read our language correctly. And it is worded a little, crazy.
I can look into that. It's something that it does come up, and oddly enough, every town is a little bit different in what they define major site plan, minor site plan, major subdivision, minor subdivision. And some will reference the state law, and the state law and the municipal land use law, I believe it specifically says a minor subdivision is anything that's not classified as a major subdivision.
Exactly. it
So
always
it's
is.
not a lot of guidance there.
Yeah.
Always has said
And it's,
So again, we have the power to take a major down to 4 instead of 5 if we wanted to make that
if
recommendation.
you want to.
I don't know what the board wants to do. I see a nod over here.
I always think of a minor as 1. I really do. Do you know what I mean? It's like my kid's house.
So let's hear from the 2 developers.
Instead of the one house that's.
Oh, wow.
Right, I like
Number
another
3.
house, that's a
I,
minor.
I've seen them anywhere
As a
between
builder, I would.
3 and 6, like,
Yeah.
6 or 7. I would say that, you do 4. That it's not the creation of 4 new lots.
Which is what we have today.
Well, no, what we have today, I think, is the creation of 3.
3 plus 1 is 4.
Yeah,
okay.
so I'm saying 4 plus the remainder. You know what I mean? So if you had a lot, you could subdivide it, and when you're all done, you have 5 lots. You have your lot that you started with, and then you have 4 new lots.
Basically, you want to expand it by 1.
Well, I think that's what it was previously, before they tweaked the language or whatever, so.
See,
Yeah,
to
because-
me, a minor is, there's no road, there's no new road, there's just a new lot.
I like Chris's idea
House.
of, anything that's not a major, because that could be 100 lots if you have the road frontage. So, because a major is defined as, something with a road improvement, but, I mean, I would say that we have a lot of open ground here, and with lots that have a lot of frontage, so, I'm just trying to strike some sort of balance, because,
Well, in a minor, there is no curbing, there is no sidewalks, there's no lighting, there's
yeah, there's
none of
no,
that.
yeah. So-
No improvements, no improvements. And years ago, we had a chair for the planning board who was very adamant against what was called a creeping minor subdivision.
That was
Where-
Jay, right?
Jay.
Yeah, and I agree with his philosophy.
Right. I mean, so maybe going with the 4, avoid some of that, because if you restrict it too much, then, people are gonna wanna just keep coming back, because we have a lot of large lots and a lot of large.
I think regardless of what your ordinance says, the creeping major applies, it's either state law or case law that says you basically can't re-subdivide after a minor subdivision within either 3 or
Extras.
4 years.
Yeah,
So you don't
right.
take a 100-acre lot, split it into 4 25-acre lots, and then come back at the next meeting and say, I'm gonna split these 25-acre lots into 5-acre lots and keep going down, and it keeps being a minor subdivision.
Right.
Although, frankly, to do it that way, I don't know, there's any way you can do that many without having to do some sort of new road or new infrastructure somewhere.
Just to get to it.
But,
yeah.
Same foundation.
Well, it also wouldn't be the first time somebody tried to create a lot that did not have any frontage on an improved street around here.
Yeah.
Yeah, would be. So
So that,
what
I
do we-
mean, it seems to be a little bit of a differing
Yeah.
opinion. on
There's a
terms of
differing
4 or
opinion,
5.
which, again, that's why we're all here. I mean, Sarah wants to go down to 2, and Jason wants to go up to
It's always 3 to
5.
anything over 3. Yeah.
Big land areas.
Well, once again, if we were driving this meeting towards a rural atmosphere, the smaller amount would comply to our vision. Or leave it the same and just change the darn wording so it's easier to understand.
Yeah.
We're not all attorneys.
You said that one was represented by an attorney, so.
And the
that's
attorney got it
pretty
wrong.
right, so That it needs to be clearer than the language.
Oh, what was that?
Oh, 2 years ago, they came in front of the board for a minor subdivision, and actually, they were going for a major, and they didn't need a major.
I always hate the term improvements. Just as a philosophical.
It's an unimprovement.
Yes.
I understand.
So it's an improvement in the sense that that's what they use to tax.
Yes.
Right.
True.
So
So I
the
think
tax
we-
assessor would definitely consider it an improvement, whatever.
Oh, yeah, ka-ching, right.
No matter how ugly it is.
So do
Okay.
we sort of have consensus?
So I will look into both definitions of major and minor subdivision and major and minor site plans. That comes up just as much as subdivisions in terms of, we get these calls fairly regularly. Frankly, I probably should have put it in here, but Ed and I will get these calls from somebody saying, you know, I'm looking to build this, is this a major or minor site plan? And then they're saying, you know, I'm putting in a parking lot for 4 cars, and I'm putting in this pole barn, I'm doing a driveway, and sometimes it's hard to determine whether they're triggering a major site plan that has all the requirements of doing environmental reviews and all these other things versus a minor site plan that, you know, they basically can send us 1 or 2 drawings and that covers it.
To piggyback on that idea of major minor, recently we ran across the Pinelands where they changed the grading plan within the Pinelands. It was something that was done within the past year or so. Backing up that thought, our engineer sometimes makes the applicant go the extra step with a grading plan that I personally don't think is necessary on a minor, especially if there's a couple acres involved and not just an acre and a half. I don't know if you know what I'm talking about.
I believe I do. And,
Good,
that's
I'm
actually
glad.
I think I'll have to look at what we said here. I think the opposite is actually in here. That is one of the things that, well, we can talk to Ed about this next time we see him, but I think his position is generally the opposite. He wants to see grading plans with everything, and I think.
He
the
does,
general
and I don't think that's
I
fair.
don't think.
Position has been lately that they want to see even for a single family residence, they want to
Yep.
see grading plan coming in to demonstrate that you're not going to have adverse impacts on your neighbors.
We had several of those applications though, when I was on the board. Neighbors coming in saying somebody built a house next door, one house, and now I'm flooded out, and I don't know.
That's what he's trying to avoid by having that
The grading plan.
requirement.
Also, Ed always wanted to be a teacher, so he wants all the grading plans so he can fail them.
Yeah, that's worse than the problem than the actual grading plan.
Yeah.
No, I think to Ralph's point, you know, if you build on a 1/4 acre lot, in a development, you got a lot more chance of impacting your neighbors than if you build on a 50-acre lot, and your closest neighbor's 2,000 feet away. So, you know, the grading plan that applies to one wouldn't necessarily apply to the other. You know. Is that correct, Ralph?
Could be a recommendation that there's a trigger for when a grading plan is required based on how far away from an adjacent property you are.
Yeah, that's
So that if
reasonable.
you're building 100 feet away from your nearest neighbor, you're not disturbing any land, but maybe a grading plan required. But if you're building 10 feet away from your neighbor, then
Then it would be
you're gonna wanna
required.
see that you're not building a giant hill dumping the water into their backyard.
Thank you, good language.
Yeah.
That is,
Can I,
remember that.
can I interject something there real quick?
As
I mean,
chair,
That's what I'm asking.
Informal meeting, so if they wanna open up to the public at any time, then.
Just a thought process, only because I'm dealing with flooding since the dollar store was built. But that's a business, but wouldn't it depend on the size of the addition or the change of how much water they're displacing, not so much the distance? You're building
That could be
a-
consideration too,
yeah, the
you know,
impervious cover.
I'm just, for somebody that deals with it, I'm just wondering.
Yeah, that's a good point. The impervious cover is truly, equally,
Let's take it into the lot size.
I mean, the building code, requires that you don't adversely affect your neighbor. As
Yeah.
it's
I think
it's
the
already
square foot of whatever.
protections in place, yeah. so.
right.
I've done some elaborate stuff with digging, I think the medical building I built, Malta Hill, I probably had an 80-foot, 20-foot deep cavern to catch all the water from the rainwater, just from the roof. And it's like, go overboard after that,
Well, it's not just
Yeah,
catching it, it's finding that it still goes back in the ground. If you eliminate 1,000 trees, you're putting that much in the ground, it's not gonna make any difference if it can't get absorbed.
Yeah, so there's a lot of considerations that can go into there, but I think that the general point being, I can talk to Ed about it tomorrow to get his thoughts as well. And again, this is something that we don't necessarily have to get to the details of spelling out exactly what it is in terms of grading plan required, grading plan not required. But the general idea being that if you're building something that you don't have to be an engineer to understand, you're gonna have very minimal, if any, impacts on adjacent properties, don't necessarily need to be required to send a grading plan in. But anywhere where it's gonna be in question or gonna be impacting your neighbors, then you should be submitting a grading plan. So, you put a kiddie pool in your backyard or on your driveway, you don't have to have Ed come knocking at your door to tell you to get your kids out of the pool. But you're building, the 6-bedroom, 5-bathroom house on a quarter-acre lot, and taking up the entirety of that lot with the house and driveway and your 6-car garage, then, yeah, a
You
grading
need a
plan.
grading
is
plan.
warranted. All right, what do we got next?
And do we have anything else on that date number 8? We seem to have.
Yeah, on this, I think number 8, we've largely covered the general intent. It's gonna require a little bit more research to add on to that recommendation a little bit, but adding some more specifics of how that would be accomplished in a zoning ordinance change. But I think we've got the general idea there that I know what I'm gonna be doing in the next couple of days of getting more information to supplement this, as well as I've got a copy of the old ordinance.
Yeah,
Jason, unless Jason wants to be like the only person in town who has that, everyone's gonna come see you.
Yeah, I mean, I'm willing to show it to you, but I can't give it to you, you can't take any, photographs.
I'm joking about that, but I did once work in a town where, I was talking about historic preservation and economic development not getting along. There was a town in North Jersey I did some work for a long time ago where the historic preservation officer, the economic development people, they didn't get along. And they had a list that had been adopted by ordinance of all the properties that are on the historic register that, you have to get, the Historic Preservation Committee had to review and approve. He wouldn't share that list with anybody. He kept it in his desk locked.
How would you know?
You'd have to submit an application for development, and once he found out that you'd applied, then he would come tell you, by the way, you're on the list, you're on a historic landmark, you gotta come to the Historic Preservation Commission. And I remember, literally, I was writing the historic preservation plan, he was very hesitant to tell me what's on his list. He was like, can we talk about it on the phone? I don't wanna email you anything. What the hell do you want me to put in the plan? I'm not even allowed to know what's historic in your town. But, so those things will happen. And so I don't know if Jason wants to be that guy that has.
This classified document, there's a lot of hubbub around classified documents. Not only did I have the ordinance, but I got the map too, so it's real exciting.
All right.
Can I ask something? Since we're talking about Jason's ordinance, that he was gonna share, what is the minimum size lot you can fit a house, a well, a septic, and all these setbacks to begin with?
I built houses with wells and septics on 100 by 100 foot lots. So I would say if you go much below 80 by 100, you probably would have a tough time.
So, but you don't make the 100-foot setback for the well, do you?
Well, no, there is no 100-foot setback for the well.
From the well to the septic?
Yeah, no, it can be reduced to 50 feet so long as you go through a restricted layer.
And what about your neighbors?
Well, as long as you meet the setbacks from the neighbors. If they have a well, it goes through, based on their record, goes through a restricted layer. Like if your well point's at 100 feet deep and your septic's up here, you're 100 feet from the well point to the septic. You meet
Well,
your.
You would be
it's
that
not
anyway.
lineal. It's
You
not
could be
lineal,
next
it
to
goes
the
this
septic and
way.
be 100 feet away if the point's 100 feet in the ground, so.
Well, that's how they measure the distance. They don't measure it lineally.
No, they do measure it. I used to be the reviewer. You do measure it.
Well, then you know that you can
horizontally.
reduce to 50 feet.
Yes, you
then.
can reduce to 50,
Right.
but we were very, you're more likely to reduce it to your own rather than to your neighbor's well, like your septic to their well.
Yeah, I don't disagree with you, but your question was, what's the smallest size lot that you can fit a house on a well and a septic?
Right.
You know, I'm saying like 100 by 100. You know, there's many lots in Laurel Lake that are like 100 by 100. I built some down there. I mean, maybe you might go with 80 by 100, but
The thing that I thought we changed our master plan because of nitrate dilution and, you know, needing to keep our groundwater safe. Neighborhoods like the one you mentioned, they're already too close together, and especially Oak Avenue, there's too many houses for the protection of the groundwater.
Well, I think it's important to know when we're talking about these smaller lot sizes, the
we're
old.
talking about pre-existing.
We're talking about lots that are already
non-existing
existing and
Yeah.
essentially are undeveloped, so it wouldn't be, no one would be allowed to subdivide to a new quarter-acre
Right.
lot in the RA district. It'd be the 1.5 acre lot size. But if somebody already owns a pre-existing lot that they bought, you know, they might have just bought it yesterday, but the lot was created in 1962. Basically, by law, you're not allowed to tell somebody that the only thing they're allowed to do on their property is build a house, but by the way, you can't build a house. That's an inverse taking. The town would literally have to buy the lot from them and then conserve it as open space, essentially. So you have to have some provision to allow them to build a residence on that property, even if it's only a quarter acre where the minimum lot size is 1.5 acres.
We have no way to protect our groundwater quality because we know based on the maps that if even at our current zoning, a total, if we don't even consider these smaller lots, even at our current zoning, a total build out, we're not protecting our groundwater, that it's going to have contamination problems. The density is just too high. So how are we protecting our drinking water, which was the goal of the master plan, if we're gonna allow all these little tiny lots everywhere to
Well,
be developed so easily?
You protected it by changing the zoning. You can build in an RA zone right now, a major subdivision on quarter acre lots, so long as the total acreage
Right,
is 2.5 per unit. So it doesn't go, but the nitrate dilution doesn't work on a 100 by 100 lot, it goes on overall space. So you're diluting it over the entirety of the tract. So when we looked at the township, we looked at the entirety of the township and its build out potential and changed that. So the nitrate dilution would be increased based on the entire build out, not the specific lot size, if you follow what I'm saying.
yeah, but if you've already got,
It basically, the nitrate dilution does not apply on a particular lot. It does apply on an area-wide
right,
basis.
that's kind of what
So,
I'm saying, is that
well-
we have too many houses already in some of these areas because they were subdivided so long ago and they were so small and the houses are so close together that we're already putting in more nitrates, which is pretty much a example. It's not just nitrates, but they use nitrates as the indicator
Right.
of what you're putting into the groundwater. So how are we protecting our groundwater if we just continue to allow lots that were approved before any of this was known or thought about to continue to be approved from now until the end of time?
We protected the groundwater by taking a set amount of area, which is the
No, that's
township.
the new stuff. I'm talking about
Right,
the
and
older
looking
lots.
at,
that
and looking at what the
you're
build out was, which is, I'm making these numbers up, say 10,000 units, and we revised the zoning, so now the build out is 4,000 units. So you've reduced the amount of units that you can build on a particular area, and therefore you've addressed the nitrate dilution model.
Well, what
And
I'm
we
saying,
can't really do much about existing
Right.
properties
Right.
anyway,
Okay.
because of legal requirements and having to compensate people if you don't give them any value or use of their property. And I think talking about the water protection is another topic a little bit later, so I think we should go on now to talk more about the number 9 and get on.
Yeah, move on. We kind of already touched on number 9 and the same we were discussing other accessory structures. But right now, between the definitions and a few other things in the code, the accessories garages are limited to 1,200 square feet max, and that's, there's a couple of problems with that. One being that that's in the definition of private garage, and since that's the definition of private garage, technically speaking, anybody who builds a garage that is greater than 1,200 square feet is not a garage anymore. And if we wanted to be really strict about it and mean to some applicants, somebody wanted to build a 1,300 square foot garage, we could tell them that's not a garage anymore, you gotta go to the zoning board, not just for a bulk variance because it's too big, but for a use variance because it's not a permitted use anymore. So it happens a lot, but it's a general no-no in terms of no actual regulation in terms of size or dimensions or setbacks should ever be placed in the definition section. The definition is just the definition of the term, what is a private garage, whether it's a 1-car garage or an 80-car garage. A private garage is a place where you store, it's supposed to be designed for cars, but most people store other stuff in there. But you shouldn't have a limitation on the size or placement of something within the definition unless there's a clear other definition as to where there's another term that says if you're over 1,200 square feet, you're this type of garage. And there has to be, you get into a lot of gray area there in terms of one, the definition is a problem, and then second, I mean, you got a lot of people in town that have, 5, 10 acre properties, and they're putting in, 2,000 or 3,000 square foot pole barns, and they're having to go to the zoning board for a variance to say that, I need to put this pole barn for my farm, and I don't think a single one of them has been denied by the board as far as I can recall when we were there.
No, but we're collecting fees.
Fees are some, I think the fee for a bulk variance is a couple $100, and then the rest of it's escrow that they pay to the engineer or planner to review.
We'll ask, Chris, what is a typical escrow for someone coming in for a larger accessory structure?
Well, minimum ask is 1,000, but that's eaten up.
Okay, so we don't return anything. So typically it's $1,200 expense, $200 for the app and $1,000 for the escrow or whatever,
Minimum.
Put a pole
to put a pole barn.
Minimum.
Minimal.
Chris, I'd say probably closer to
That's your
2,000.
checks you send back to the applicants. The more important question.
All right, so we need to address that right now and ask our panel what square footage is fair before we need to go to a variance.
And what we had suggested last week, we didn't touch on this, is the idea of a sliding scale. If you got a 1 acre lot, maybe 1,200 square feet is appropriate. You
Yeah,
got,
but reducing, taking out the existing garage.
Right, the attached garage, yeah, 1,200 feet, not inclusive of
Not inclusive of the
an
existing.
attached garage to the home. And
yeah, well, by definition, anything that's attached to the principal structure is part of the principal structure. So if you have an 8-car garage that's attached to your house, it's not a private garage, it's just the garage on the side of your house. When it's detached is when
They
it
were
becomes
not.
an accessory structure.
Yeah, but the definition calculates in
Yes.
the attached garage to your house.
I don't think
Currently,
it does, does it?
Yeah.
Currently, yeah, it
yes,
does.
Chris?
Yeah,
Take
All right,
that
I'll
out.
look at that.
yeah.
Yeah, no, it does.
Or that's how it's always been interpreted and applied by the zoning officers that I'm aware of.
I know exactly.
Yeah, and people come in for variances because.
Yeah, everybody coming in for a variance is coming in for a 1,200 square
And
foot
did they
building.
calculate your current?
Calculate my current.
Yeah, because they have an attached garage or a shed.
That's right.
So Chris, we have testimony from Steve here saying it just happened to him.
About a year and a half ago.
They calculated his existing attached car garage and then started calculating
Okay,
the
if
addition.
if Frank was doing that, that'd be pretty unique. I don't know of any other town that would do that.
Well,
You're out of
this-
the statute of limitations, get your money back.
Okay, well, obviously I got no money back.
Yeah, we just reviewed an application like that, and I think he only wanted to build a 900 square foot garage, but his existing garage attached to his house, or an existing garage, now maybe it wasn't attached to the house, but I believe it was. It was already 800 square feet or something, and then that had to be added in, and then made him have to get a variance.
That doesn't seem.
It doesn't make sense.
Should be clarified.
Yeah, so I think we were good with 1,200 square feet regardless of lot size, so long as it didn't include an attached garage, is that correct?
Yeah, exactly.
I would even recommend that for larger lots, you can
Yeah,
go up
then
to.
we want to go up, yeah.
Right.
'Cause it's
We
not
really
uncommon
don't
to
have
see
any
somebody-
larger lots greater than 6 acres. Because then typically they fall under the
Yeah,
guides
cube
of
farm.
a cube farm, and then there are no restrictions. None.
But you can specify, there are people who have larger properties that are not farms, and they've still been putting in.
Very, very, very
I'm seeing
few.
it here, seeing it in Monroe, I'm seeing it in a handful of other towns that I work in where people are putting in large garages for whatever reason. So if people just have collections of cars, or some people
Correct.
collect older cars, and they've got, 6 or 7 of them, and they don't want them to all be in the driveway, so they build a,
Currently, we have to have this accessory structure built behind their primary residence. Do we want to change that? or keep
Well, no,
it the
I
same?
think you want to keep that, you don't want someone
Okay.
putting a pole barn in the front
All
yard.
right, just checking.
Yeah. I mean, I'll just throw this out there, up to a half acre lot, 1,200 square feet, half acre to 1 acre, 1,500 square feet, 1 to 2 acres, 2,400 square feet, 2 to 6, 3,000.
And hold it at 3,000.
Yeah, or above 2, 3,000.
I think the
And then
purpose,
anybody that's a Q farm, they're gonna
They're
take
exempt.
about 1 million square feet.
they're exempt.
They want some bigger, just-
The intent of the ordinance, I think originally,
Cut down the amount of people coming.
right, the intent of the ordinance I could see was to discourage home businesses in a residential zone. I mean, like, who needs a 5,000 square foot garage unless you're repairing automobiles for profit? And those businesses, of course, have sprung up with no zoning approvals.
So, yeah, they don't get the zoning approvals for going, so. it doesn't-
I know that, but
doesn't matter.
the intent of the ordinance, I believe, was to eliminate
Right.
that type of scenario.
Enforcement is the hard way.
A lot of businesses want to store landscaping equipment.
now that's another thing I see quite a bit of. And, there's always a distinction between somebody who runs a landscaping business off-site and they come home, they bring some of their equipment and store it in the barn versus somebody who stores all of their equipment and has all of their materials in the piles of gravel and mulch and things all over the yard. Those are always issues. See that in-
Well, do we want to specifically, be that specific about the sliding scale?
No.
Well, if we're gonna have a sliding scale, I think we need to
I
be.
think that makes
yeah.
sense,
That
yeah,
makes
that makes
sense.
sense.
The other
It's
thing,
workable.
the zoning people deal with it.
Yeah.
Gee, that one was faster than I thought.
Okay, number 10 is relatively simple. This is something we've come across a couple of times. They're talking about building pole barns. Right now, so I think about half of the non-residential districts, it specifically says that storage is permitted as an accessory use, but in a couple of the non-residential districts, the business district in particular, it doesn't say that storage is permitted as an accessory use, so that could be interpreted as if somebody wants to put a storage shed, even if it's one of the, a 10 by 10 shed you get from Home Depot for $800, that they could be required to get a use variance for that. And I think, especially when you have some lighter industrial businesses or anything, landscaping companies, things like that are permitted uses in their district, they should be able to put in a storage shed without having to go to the zoning board, assuming they meet other requirements.
Again, the intent of the ordinance, I believe, was to discourage storage of things not in a building. No outside storage. Again,
Well, I mean, this doesn't say no outside storage, it's just storage is just simply not listed as a permitted
I
accessory.
know the word
use.
storage, though, grows.
We can change it to specifically say
Don't-
indoor storage
Okay.
as an accessory use. Storage in an enclosed, fully enclosed
Structure.
structure.
Is a permitted use,
Yeah.
is what we would be saying.
And do we,
That's a separate use, that's all.
I only see one that I called up quickly. A storage facility is a place for the storing of motor vehicles. Are there other definitions of storage in the code? I just pulled this one up.
That's on Franklin's code right now?
Yeah.
Okay, that's probably something that should change,
That's
because
I think, wouldn't anything with business use be part of the principal use then? Like,
I mean, it depends. It would be part of the principal use, but still an accessory structure. And then, depending on what they're using it for,
that gets a little bit hairy, it's like.
it does get a little bit hairy. That's, New Jersey, other states are different where you have to specifically prohibit things. New Jersey is, if it's not expressly stated that it is permitted, you can consider it prohibited. So that's why I'm always wary of what, lists of retail uses. If you don't specifically say that,
If you omit one, it means
if
it's
you omit one, it
permitted.
means it's not permitted. Like if you say a beauty salon is permitted, but you don't say a barber shop, then somebody, if they really want to be mean, can say your barber shop is not permitted here, but you can have, 15 beauty salons. But anyway, I think my mind's going on a little tangent here. But it would be much easier if you just simply say if storage is permitted as an accessory use, and there's no question whether or not it's accessory storage or separate building, that no one has to go to the zoning board for storing the stuff they already do at their existing business, just in a different shed.
So I guess if that particular business were to now, start operating out of that storage shed, that would be a zoning issue.
Well,
be dealt
if
with
it's
by
on a
the-
residential property, and you put in a storage shed in the back and you start running a business out of that, that would be a zoning issue, yes. But I'm
Yeah,
not-
that would be the same principle with the business, is what you're saying?
I'm talking about with the business, it would be that, since storage is listed as a permitted accessory use, if you're proposing an accessory storage structure, it could be seen that that would need a use variance, depending on who's interpreting the code at the time.
I think like to Ralph's point, say, I have a 10 by 20 little office building that I run my landscaping business out of, and I want to put a pole barn out back for storage. And then the next thing you know, I'm running a full-blown repair shop out of my storage, quote-unquote, storage building. I guess that would be something
possibly
the
be a
zoning
zoning
officer.
issue. But if all you're doing is storing your landscaping equipment, it probably
Right.
wouldn't. But like, it all depends on who's interpreting the code. We've had these come up where businesses have proposed pole barns, and we did not treat it as a use variance, but you never know 5 years down the road, who's gonna be the zoning official, who's gonna be your planners and your engineers and the attorneys, and they might interpret things differently. Whereas if it's expressly stated in the code that enclosed storage is permitted as an accessory use, and there's no question.
Right. I guess regardless though, in the situation that you had a business, putting that type of use in, it would require a planning application to the board, correct?
Yeah, if you wanna
It's
put
not
a.
like somebody putting a shed at their house.
If you want to put a separate business in, that would probably require a use variance if they're two entirely separate businesses, Or if you're in a residential district and you want to start working on cars in your garage and actually turn it into a business as opposed to just, somebody comes over and brings their car and you put new brakes on. I mean, people do that all the time. It's not necessarily a business. But if you're actually running a business where you're advertising and strangers are coming and dropping off their car, then it becomes a zoning issue. And, I mean, people will do that whether they have a 5,000 square foot garage or a one-car garage sometimes.
Yeah, we know that.
I have a crazy question, just because I'm thinking deviously. Can storage ever be considered a warehouse? By somebody who wanted to put a warehouse, but he called it storage? Like, in other words, do we have to be specific? Especially if we're gonna be cracking down on warehouses in any way. I'm just thinking,
I would say yes and no, and that, I'd have to look at the entire list of definitions. I've done this in a few towns now, where we put together ordinances specific for warehouses, largely following the state guidance. There are plenty of terms in Franklin's code as well as any town's code where you could look at something saying storage, and somebody could say, well, a warehouse is just storage. It happens to be 1 million square feet of storage, but it's just storage. No, that's true. That's a literal statement. A warehouse is a big box to store stuff. But if you have another definition in your code in that same zoning chapter that says, that defines what a warehouse is, it defines a parcel hub, it defines a distribution center, defines cold storage, all these things, and they more clearly fall under that definition, then wherever you have regulations for that definition in your code would apply.
I don't know if we have any of those differentiations currently.
No, most towns did not up until the last 2 years.
Can we initiate and pick a number like 50,000 square feet as a warehouse, anything less than storage?
that'll probably be our next thing when we get into warehouses, but I think we should, I mean, if 3,000 feet is the max
For residential.
for
Yeah, but we have businesses that need to store
Yeah.
parts and supplies.
Well, I think the key word here is accessory. So you can't have,
Yeah.
a 300 square foot office and put in 1 million square feet, because then that's no longer accessory. Your accessory can't be bigger than your principal.
That is, if the only building on the property is the storage, then technically, whether it's 5,000 square feet or 500,000 square feet, that's essentially a mini warehouse. And storage or warehousing is the principal use of the property. And if it's permitted there, it's permitted there. This is what, and we don't necessarily have to talk about it tonight, since later on in here, very next, number 12. But, yeah, so a lot of towns have run into this issue where their codes were written in 1975, when a standard warehouse was, 20,000 square feet, 50,000, 100,000 square feet was considered a big warehouse. So they just had in their industrial district, it had, light industry, light manufacturing, all these different things permitted, and warehousing and storage, distribution facilities permitted on the assumption that it was gonna be a 50,000 square foot building with 8 loading docks for trucks. And somebody puts together 3 pieces of property there on a couple of farms, and now all of a sudden they're getting applications for 1.4 million square foot warehouses with 125 loading docks for trucks on each side of the building. And then they're, I don't wanna say powerless, but then they're looking at these and saying, whoa, this is not what we envisioned there, but by code it's allowed, and the only variance they need is maybe,
Previous cover.
yeah, or not even that sometimes, because they have a lot of, there's warehouses with a lot of public opposition, but they are essentially by right applications based on codes that were written 30 years ago.
So the goal of this committee is to protect us from that happening.
Well, that's one of many goals potentially, if that's what you want to see happen. I'm saying that there are plenty of towns that want to fight warehouses, and there's also a couple of towns where I've recently done their master plan reexamination reports, and they've specifically said, hey, we want to get some of these big warehouses. We're tired of seeing all these other towns get the tax dollars from these warehouses, we want them here. But they happen to be towns that are, not within 5 miles of a state highway, so I don't see it happening. But there are towns that say that I guess are desperate for tax revenue, and they will say specifically, what do we need to do to attract some of these bigger warehouses? So I don't know what Franklin's position is on that, or your, I can take a guess at what your positions are based on what you just said in the last 2 minutes, but I don't know what Franklin's position as a whole is there. So my suggestion is to avoid getting something that you don't want to see, then the codes would need to be updated there. But we can talk about that next time if you want, or if you want to talk about it now. What time is it now?
Updated.
8:30.
Way to go, because then you have some teeth, and you can always come before a board and ask for a variance.
Right.
But you don't have the option, it just gets jammed down the throat.
Yeah, we need the
I'd
definitions.
much rather have.
Yeah, I think we do feel that we need to specify, although they're only allowed in two zones, and neither, when you look at the zoning map, none of those seem ideal places. Business district and light manufacturing.
Interchange commercial.
No, actually not.
No, really? Okay.
And when you look at them, all the trucks would have to go through either Malaga, right through the middle of Malaga, or right through the middle of Franklinville. So neither one is particularly desirable. Although I think that we could use a lot more information. Going through the state guidance was very helpful, but it doesn't tell you exactly what to do.
No, the state guidance was written for the entirety of New Jersey,
Exactly.
which Newark and Jersey City are very different from Vineland and Franklin.
One of the things that I was wondering is, I mean, we're going to go into this in much more detail, I guess, at our next meeting, but can warehouses become a conditional use?
Sure.
In which case you could then take the time to specify what those conditions are. And that would give you a lot more
Exactly
control
we've
over
done
what you get.
in a few other towns. We've made them conditional uses, and some of the conditions being that based on the size of the warehouse, that's the minimum lot size gets bigger, and then the buffering requirements get larger.
Right. And, I mean, you could even go so far as to perhaps place conditions on allowing certain sizes or certain activities or certain, if they were willing to utilize more electric vehicles or those kinds of
I
things.
mean, there's a lot of options, and it's something that I don't know that we need to address every detail in this master plan document, because obviously the township committees can have their own thoughts on what they want to see. But there are, I mean, for one town, we literally did a master plan subsection. We spent 6 months doing nothing but addressing warehouses and then creating a new ordinance specific to warehouses. And that was a 6-month to a year-long process just on warehouses.
I can see us, I would like to get some specificity in there, only because when we were doing the master plan rewrite, it was the big box retail. It was the big thing that nobody wanted. But I think warehouses are just gonna keep coming because everybody wants their stuff and, overnight, now it's the same day, now they want it in an hour. The only way you're gonna get that is with warehouses. So, I mean, has everybody read this, the state guidance document? This is very valuable with defining the different kinds of warehouses that exist.
Yeah, I can send it to everybody.
It's really worth looking
It's
at.
definitely
I
worth
can't see a
reading.
warehouse
It
being
tells you
built.
what the impacts are, like what
Not
kind
all the
of
major
traffic,
highways that you
everything.
normally see where you would put a 1 million square foot warehouse.
Maybe not a million, but you do have Route 55 going through the middle of town. So if somebody could get quick access to 55, then they might want to do it.
Officer
But there's all
Planning
kinds of
Advocacy.
different
Let's see.
warehouses,
Yeah,
and what
I
they,
understand
the
that.
traffic
Just
impact.
a million
we should-
square foot warehouse
Right,
is not
so
going
maybe
to
before we get into this.
Probably not, but you never know.
That's the
I've
reason
seen-
why along 322, you have the turnpike, you have 295, you have 95.
I can
you
send it to
That's
the.
city.
Everything right there.
That's not wrong.
Yeah, please do.
Distribution.
That's weird.
Yeah.
Is it on the
those-
back?
Can you do it?
I mean, that's weird that they don't have it.
I hadn't sent it to anybody, but they're, the state guidelines, they were put out probably about a year ago by the Office of Planning Advocacy. It's just called something like Warehousing and Distribution Center Guidelines. I can send it to everybody tomorrow morning.
All right,
Okay,
yeah,
great.
there's no website on here.
I have a question for Chairwoman.
Yes.
You mentioned there's two spots or parcels in Franklin Township that currently permit warehousing?
2 zones.
2 zones.
Yeah.
Where are they?
Business and light manufacturing. The business zone is the one that is the site where the solar, the large solar array is gonna go.
On Fry's Mill Road.
On Fry's Mill Road.
Uh-huh.
And light manufacturing is spotty.
There's
And
4 of them.
stretches, there's 4 small locations.
Okay, so they're basically along Route 40?
And 47.
Well, that's not 47 on the left, that's along the
Okay.
railroad, where Railroad Avenue stops.
Oh, really?
It's very odd that it's that way, and it already has, Windsors in it.
Oh, okay.
Is there square footage attached to that as far as maximum permitted in LM or the?
I don't know,
No.
I think it just says warehouses.
It's a permitted use.
It's just a permitted use, yeah, it says nothing
Can
else.
we add a maximum square footage permitted?
Well, that is what we're kind
That-
of
That's
asking.
where we're getting close to that.
I've not seen it done with warehouses. I know some towns used to try and do that with the big box stores. They would put a max square foot of, 75,000 square feet or 100,000 square feet, whereas some of the super Walmarts, they wanted stores of 150 to 200,000 square feet.
The only reason I say that is because we want to maintain our rural character. Is it a requirement that we, is it a requirement, a state mandate, that we have a zone that permits mega warehouses?
There's no state mandate. You're generally not, I would caution against trying to put a cap on the size of any one individual building without some sort of other caveat there. I mean, you can have impervious coverage limits based on, a percentage of the lot. You can have building coverage limits based on a percentage of the lot. But if you just flat out said that the maximum size of a warehouse shall be 100,000 square feet, unless you're allowing multiple warehouses on the same property, I think that would get challenged. And I don't know how well that would hold up. I do know there towns had tried to put caps on, Walmart and Home Depot and things, the big box stores, and largely most of those were, I want to say, found to be invalid because they're kind of arbitrary numbers. So you can set it up to where.
What's arbitrary numbers?
it's
Size
just
without
saying-
the lot size
Just
of the
saying
lot.
100,000 square feet is the biggest building allowable without specifically tying that to some public purpose as to why you came up with 100,000. You can restrict the size based on if you have 500,000 square feet of area, then your max you can do is a 100,000 square foot building. But if they have a bigger space, you kind of have to allow them to do a bigger building. There are many other restrictions you can place on them that would otherwise limit the size without specifically calling it a cap on the size of the building of a specific number. That would be probably getting challenged, and I don't know that that would be able to be withstood in court if somebody did challenge that.
Are we certain? Or are
There's
you-
certain ways you can probably put a lot of restrictions, not restrictions even, but requirements that the town wants to see that reduce the impact of these large.
Yeah, like I said,
Facilities.
what we've done in other towns is the conditions are that the bigger the lot you have, we don't specifically say, if there's a max size of the warehouse, but the larger you go up, the smaller percentage of the lot you're allowed to cover with buildings and area, and the larger the buffer is required. I think what we did in West Hampton was something like a 5 acre was the minimum for some of these, and there's a sliding scale of 3 or 4 rungs. If you go up a little bigger, then you go from a 100-foot buffer to a 150-foot buffer, and 150-foot front yard, side yard, rear yard setback to 200-foot setback. So it's, the bigger you go, the more buffering and setbacks you have to have. But there's no actual cap on the building that says that once you reach this
You
limit,
make it
that's
so
too much.
restricted that it would cost too much to build.
Yeah, that's true.
Yeah, you have to put in standards, like you said, that make sense
It
based on.
makes sense, yeah.
Well, you can't just arbitrarily say
Yeah.
100,000. It doesn't matter if you have a 10-acre lot or a 500-acre lot. You know what I mean?
You
Like,
can-
it's
you
already
can-
basically regulated through the zoning.
Lot size?
The zoning requirements and the impervious cover, they're restricted based on whatever that
Yeah,
underlying
you
zoning
you
is.
can do it as a percentage of the lot, generally speaking, is gonna be fine if you say no more than 25% of the lot can be covered by buildings, and then whatever the lot size is, then that's gonna be the cap. But in general, I would advise against trying to put a cap as just a number on the size of a
Just
warehouse.
make your
or a
setbacks.
building. And if they meet the setbacks, if they meet the buffering requirements, then that's gonna determine the size. And the other question you said, there's no state mandate that says you have to allow warehouses, but it's just like, I mean, they're any other legitimate business use, and the zoning ordinance in general overall, I mean, you don't have to have, it's understood you're not gonna have
You
everything.
yourself said in the state of New Jersey, if it's not written in the code as a permitted use, it's not a permitted use, as opposed to all the other 49 states.
Well, every state is different, but New Jersey is one of, I think, like 30 states that do it that way, there's about 20 that do it the other way.
And so, that's law, or that stands up in court.
Well, yes and no. It would mean they'd have to go to the zoning board for a use variance, but by law, you're generally supposed to, within the zoning ordinance, allow provisions for every possible, just about every possible use.
Why? Like,
Because you can't zone out
A
legitimate
nuclear power
businesses.
plant,
Well, there
next to
seem
the
to be some
development, I
uses.
wouldn't go to the zoning.
There's
board.
really only two things that you don't necessarily have to include in your zoning ordinance. One being a nuclear power plant, because those are regulated at a much larger level, so if somebody wanted to put in a nuclear power plant, that'd be a much bigger issue. The other is adult businesses, you don't necessarily have to zone to allow them, because there are provisions and there's case law that says if the need for adult businesses is met in the larger region, then you don't have to allow them in your town. But generally speaking.
And cannabis as
And
well, right?
cannabis, yeah.
Well, cannabis is the other one, you don't, if, they gave every town the right to opt out of cannabis or opt in. But generally speaking, you wouldn't be allowed to prohibit otherwise legal businesses from your town. Now, there's always cases of, when you're making the list of permitted uses, or something you just didn't think of, whether it's a new industry that popped up, or just, there's always something you forget. I mean, literally, we just had this issue in another town where we did the warehouse ordinance. Right after we spent a year and a half doing the warehouse master plan and the warehouse ordinance, somebody came in with an application for self-storage, and they didn't have anything in their code that says self-storage is permitted. And we're like, we just did all this work, now somebody wants to build 150 mini warehouses in a building, we don't have anything in the code for that.
Right.
So what happened? Did they go to the zoning board and got
They-
a variance?
They went to the board to ask for an interpretation of the code as to whether a warehouse would be permitted, or a self-storage facility would be permitted in certain districts. And the zoning board, well, it's a joint board in that town, so the land use board said, no, it's not currently permitted. So what that applicant has done at this time, they've petitioned the township council to say, hey, can you adjust your code to say that self-storage would be permitted here?
And what did council say?
It's pretty recent, so they haven't done anything just yet, but they're probably gonna be.
So they could deny it, the council could say, no, this is how we wrote
But they
the
might,
ordinance.
but there might be a court case, and they
Well,
might
that's
get
all-
sued for
Maybe
it.
setting up for a challenge at that.
Yeah,
point.
it'd be very hard to defend, I mean, it wouldn't be me, I'm not the attorney, so it'd be either her or Matt Lyons going to court trying to, it'd be very hard to defend a strict prohibition against warehouses that just flat out says warehouses are not permitted here.
Our code does say that concrete plants and are not permitted. It actually says
Asphalt
that too.
plants,
Certain things that have been sort of
And
really
asphalt,
deemed
that's right.
noxious uses, like concrete plants or
Yeah.
tanning
Asphalt.
facilities and things
Yeah,
like that.
Noxious uses,
How
that's
about
right.
unsightly uses,
Well,
like
it-
mega warehouses?
It's more what they put out.
Well, that's why you would use conditional, you make conditions.
Okay, we've got.
We gotta move
Yeah,
on.
we move on.
Yeah, we gotta move on.
I understand what you're saying, and there are towns that are trying to do that to some degree. I would not, my advice would be that you have to allow warehouses, at least as a permitted use somewhere, but you do have the authority to put pretty strict conditions on it.
And
I
think
would
it-
like to be real specific too, like when we get into this, like tighten it up as much as possible. I mean, not a year's worth, like what you were saying, but,
Well, what I can literally do, I can send you the master plan and the ordinance we did in West Hampton.
That would be great to see.
They have the turnpike and 295 going through their town, so they've been a big target for warehouses.
Oh, of course. Interestingly, Pemberton is a big target,
Yep.
and the guy from Pemberton said that they have decided, or they are not permitting facilitation,
Distribution.
Distribution facilities. Well, wait a minute, the one that would deliver locally.
Right, distribution.
Last
Like,
mile.
I was talking about fulfillment centers.
Fulfillment centers, that's what it is, which I didn't actually understand why they wouldn't be doing.
Well, the fulfillment center, usually, they're the biggest traffic generators.
Yes, they are.
Because the distribution centers, they have the big trucks coming, but you don't get a truck coming every 2 minutes. Or the fulfillment centers, an Amazon fulfillment center, there's one in West Deptford. I think they have something like 400 or 500 parking spaces for the Amazon vans, and they do that. They have the Amazon vans that all get loaded up to go do the deliveries of the stuff that everybody ordered yesterday. And so the Amazon van goes from the fulfillment center, usually drives to another warehouse to get what they're needing delivered that day. And then they also have people, the independent contractors in their own cars who then drive to the facility. And they line up, 50, 60 of them in the morning. They drive through and they don't even get out of their car. They just have somebody come and load their trunk and load the backseat of their car, and they drive off to get their instructions basically emailed to them on what they're doing that day.
Oh,
So those are the big traffic generators.
I would
okay.
think though that tractor trailers probably are going all night long, and the vans aren't, right?
It depends. I mean, the vans, I don't know if there's any restrictions on them, but sometimes the tractor trailers are going pretty late at night. I do remember once up, it goes around Hamilton area up in Mercer County. I was up there for a meeting that went until about 1 o'clock in the morning, and as I was leaving, I noticed a lot of tractor trailers getting off the turnpike and going towards some of the warehouses up there, so they do. But it's something that's, it's a little bit difficult to regulate, at least within the zoning code, in terms of hours of operation of some of these things.
Yeah.
But naturally, the vans, I mean, everybody's asleep, so like, unless they're doing long haul, which if they're doing last mile, I would think that they would tend to
They
stop
do, but there are
driving
also,
at night.
the tendency of those last mile ones is there's certain hours in the morning where they're all just stacking up, because everybody's showing up for work at the same time to pick up their packages to go make their deliveries.
Yeah, so that makes for.
So I mean, they'll say at an application, yeah, we're gonna stagger our working hours, we're gonna stagger our shifts, and then
Yeah, they won't.
a year and a half later, you got a new manager who has absolutely no idea what the zoning approval was, and says we're gonna stagger our shifts, and he says, everybody here at 7 o'clock in the morning.
That's right, because the guidance is good on talking about staggering things to make it all work better,
It's
but
difficult to enforce that,
very difficult to enforce.
unless you wanna have a cop out front every morning.
Yeah, that's right. So you will be sending us,
Yeah, I'd like to see that.
circulating the guidance document or their link, or is that right?
That's
Yeah,
what he said.
I'm gonna send you the state guidance document, I'll also send you the plan and the ordinance we did for West Hampton.
Both would be great, okay.
I'm not gonna send you any stuff on Pemberton though, because my firm actually did some of the plans that permitted them, so a few of those warehouses.
Well,
And we've also done some more recent ones for them that do the exact opposite. We've done both in Pemberton.
Oh, that's fine.
I will say, I have driven across a couple of the sites in Pemberton where they built some of those large warehouses, and I'd say like, damn, I did not do it, not me personally, but there is a CME logo on one of the plans for one of their bigger warehouses.
Okay.
You know, it's interesting, we did this seminar the other day, and I typed in a comment, they never got to it, but it was like, the municipalities dealing with this, it's like whack-a-mole. Why isn't the state, apparently Trenton backed out of doing anything, didn't he say that Trenton decided not to do a statewide, growth area for warehouses? I'm pretty sure I heard him say that they're leaving it up to the municipalities, which is ridiculous.
In general, the state law, the municipal land use law, does delegate to the individual municipalities the authority to zone, with the general caveats of that every town has a responsibility. There's the Fair Housing Act that says you have to provide your fair share of housing, so you can't just zone out housing. And then in general, your zoning ordinance is supposed to accommodate to some reasonable degree all known legal uses at the time. To the extent you can put it in your zoning ordinance, and it's something that you should be aware of, and it is a legal use, you have to have some sort of provision for it, that it's allowed somewhere in town. And then there's always questions of, are you allowing enough space? And if it's an industry that's growing, if you're already built out in that area, do you need to provide more? Those are questions that usually get settled in court when somebody tries to challenge an ordinance. But in general, unless it's some sort of use like a concrete plant or an animal, the tanning facility where they used to do making the leather, they tan the hides.
Mhm.
That has a much longer history than warehouses do of being a particularly noxious use. The type of use like tanning and concrete plants are the reason we have zoning in the first place. And
That's
up
right.
until the last 5 years, warehouses weren't really a big issue. So there might, who knows, maybe one day at the state level, there will be a larger ordinance stating specifically that warehouses above a certain size have to be, X amount of miles from the Garden State Parkway, or, actually, no, I don't think they allow trucks on the Garden State Parkway,
No,
so it'd have to
they
be the
don't,
Turnpike
right.
or 295.
Right.
Something along, I don't know, but you can't really count on that, so.
It's more like, it just to me makes sense that the state that is responsible for all of the transportation hubs and everything, they're sure fine with affordable housing, and it's like not telling us where to put them, but doing a growth area. Where does the state think?
Well, they keep
These things should
encouraging,
go, and
they
they're-
keep encouraging regional cooperation, but they don't
Yeah,
actually
they're
come
not
out with a
helping,
regional
and so
plan.
we're doing whack-a-mole. And it just makes no sense at all. It's a major, warehousing is a major thing. People, that's how we're buying it. It's gonna keep continuing that way.
Well, there is
It
some
just-
question as to whether the trend will continue or whether we'll end up with empty warehouses.
Well, yeah, it could.
So it's gonna change in some way.
Like the office buildings.
I would suggest that we have only 10 minutes left, because I really think that a meeting should only last 2 hours.
Yes,
And,
Suzanne.
I like that.
So we're gonna jump back to number 11, we skipped over number 11.
We did skip over a number
Oh,
of,
the sidewalks, I didn't even.
the sidewalks issue, but, we'll take up warehousing next time, and obviously we'll have a lot. Maybe you will have, well, we'll look at the West Hampton,
Yeah.
and that'll help guide us, I guess.
Their situation is a little bit different. They're a little more suburban, a little less rural, and they have more
Right.
highway access than you do. But that plan we did for them generally follows the state guidance to a large degree, as well as provides quite a bit of standards. We differentiated between 3 different types of warehouses. Conditional use standards based on the type of warehouse and the size of the property and the size of the warehouse they're proposing to do, as well as a multi-page list of additional zoning and design standards for warehouses.
Nice.
So that'll be great. So let's talk briefly about sidewalks.
Yeah, that one is in there right now. Your code says only for subdivisions, it's in the subdivision section of the code that sidewalks are required along all street frontages, but it's not in the site plan or zoning code. Therefore, an interpretation is, and sometimes you get into this, if you're not subdividing, then no sidewalks are required. So you could have, in some instances, technically, it's not entirely clear whether or not the code wants to require sidewalks, and then that condition be waived, or if sidewalks are not required unless you're doing a larger subdivision. So that's
It
something
needs
I
to
think
be
should be
clarified
clarified in the
as
code.
to what we want to
We
have
waived
happen.
them all the time. I know when I was on the front, because, well, we didn't like them when I was on the board because they look so suburban. And nobody's ever walking on them anyway. They're driving 2 houses down to see their neighbor. Nobody's walking on them. And I don't know, that's how we felt. We just didn't
I mean,
think.
I even get asked to take an account of, I think we took a 40-foot out in one project in Elm.
Really?
Yeah, took 40-foot of sidewalk out. The neighbor didn't want it.
Well, yes.
I mean, are sidewalks required by RSIS?
For new streets, yes. If you're not building a new street, but you have 100 feet of, 200 feet of frontage, it becomes a question, it's not entirely clear in the code whether a sidewalk is required or not. Because it's required under the subdivision code.
So we should make it friendly for major subdivision.
I mean, that could be clarified in the code whether or not that's the intent or not.
I think that, I mean, and I would require it on any major
Where
site
there's a
plan.
lot, where there's a lot, there's sidewalks all there.
There is an exception.
I've never ran into one.
They were great bargaining chips though.
About 2 years ago, we had a minor application on Fries Mill Road, not far from Delsey.
Yeah, the poor guy agreed to it and came
And
back
he, and
they
then,
got
the-
to remove it,
and
right?
Ed made them put in sidewalks for the
I
simple
don't-
reason that the
Wasn't just that,
chair.
I was in support of sidewalks
Okay,
there too.
the chair made a comment that that area was indeed the Delsey Regional Cross Country track and training area. So the board felt that sidewalks would have been helpful in that area. So again, it's by the site itself, even though it was a minor application. However, 2 years go by and the applicant came back and asked for us to waive it, and we waived it. And the reason we waived it, believe it or not, Delsey changed their track layout for their cross-country course.
The only thing I'd add to that, obviously sidewalks are not necessarily warranted everywhere. But it's also, if it's in the code, it's a pretty easy condition to waive during subdivision or site plan review. You can say, all right, there's not a sidewalk within a mile of this property, putting in a sidewalk to nowhere doesn't necessarily make any sense. But if it's not in the code and you do want to see a sidewalk there, you can't enforce that. You can't say, we really want to see a sidewalk here.
So it should be made clear that, what, that it's not just subdivisions, I mean, where a new street is coming in.
My suggestion would be that it's clear that under
Under
major
site plan.
subdivisions and major site plans, a sidewalk should be required. Should be required.
And they are.
No, not under site plans, you said.
Under site plans, I don't think it is
Oh,
technically
okay,
right now.
okay.
We used to just use them as bargaining chips.
True.
To get something from the developer, well, we'll waive the sidewalks if
If
you
you-
do this. Right. Worked every time. It's wonderful.
Well, yeah.
I believe if we were reviewing.
Yeah, I don't like that, yeah.
I think if it varies for lack of sidewalk, we'd probably be citing the subdivision code, which technically speaking doesn't apply if they're not subdividing.
Okay,
Yeah, so, just to clarify that, we would like to add it for major site plans, correct? 'Cause I mean, if you're doing a major site plan somewhere,
It's gonna have it in there.
more than likely, you may need to put it in, you know what I mean, if you're in a major intersection or in one of the village areas or something, so.
Can I
And
add
if not, you
something?
can ask for a waiver, so.
I just wanted to say about sidewalks. In the Malaga and the Franklinville Village areas, they're very well used.
That's
Yeah,
what
there
I'm
would
referring
be
to.
And what
Yeah.
the concern is if you're in that village, do the new ones have to extend it? In other words, because we did get a couple grants a few years ago. And for example, in Franklinville, they took it from the school all the way up to the community center because of the library.
Right.
So they were, but it's like, if there's houses being built along there, that would be something you wouldn't want to restrict, what I'm saying, you would want to
That's a good
continue
point,
those,
yeah.
that sidewalk that wasn't completed. But
Maybe
the
on a
goal
major
was,
highway.
you would
That
want
is
to
a good
require.
point there.
You would want
And
You
it
would want some sidewalks.
right, and in Malaga, they use it all the time between the churches and then, if that ever became a senior citizen where you would, like, let's say the DiMatteo farm, and then they would be using that to get to their diners, to the CVS, to those areas. So I'm saying if that was ever, constructed, you may want to think of that for the village districts.
That makes sense.
That could certainly be a recommendation as
Yeah,
well, but it's not
villages,
just
yes.
by major
Yeah.
subdivision, minor subdivision, major
Just
site
have
plan
to
minor, but also
extend them,
the
yeah.
Malaga Village District,
Right.
all developments required to have a sidewalk along the frontage. and
Because
then-
then that has an economic development aspect to it too, because it's encouraging people
Yeah,
to
but
walk.
Walk.
very, very well could be zoning district
Scooters.
specific as well. It doesn't have to be just by major or minor.
Right, but in the villages,
The two villages.
Yeah.
Obviously, it makes a lot more sense in the actual villages where people might actually walk to have sidewalk, whereas
That's right.
you really don't need sidewalks where you have a farm with 400 feet of frontage on property and 800.
What about sidewalks and access to the high school or the grade schools where kids could walk to school?
Well, I'll put it this way, it gets a little confusing when you do it that way. Monroe Township, just in the north, their ordinance has sidewalk zones, and there's no map showing it, it's just literally the zoning ordinance has a full paragraph stating this street, this street, this street, this street, creating a giant box around Williamstown,
Right.
another few boxes, so there's like 30 streets named and set up the perimeter here, where it says in this zone sidewalks are supposed to be required, in this one they're encouraged, which I don't like using the word encouraged in a zoning ordinance because it's either required or it's not. And then other zones will say it's nice to see, but it's not necessarily encouraged or required. So they have like 5 sidewalk zones. It's kind of hard to interpret where you fall on that zone or whether or not, when I'm writing my report, do they need to put in a sidewalk or not? So
Well, one other quick point I'd like to make regarding, these sidewalks, there's also jurisdictional issues. If you're talking about the village area, with DOT, stuff like that, you don't
the state or
require
county is gonna have to say in it.
municipal road. I mean, they might say, no, we can't put a sidewalk there, you know what I mean?
But they're putting them everywhere, even where they don't belong, so you would think that they would.
No, I'm just saying that the
Yeah.
municipal planning board can't require something in a
Right.
DOT or county right away. You know what I mean? So,
Well, you can require it as part of your site plan, but if the state says no, then
You can't force somebody to put something,
You can't force
they
them
don't
to
have
say something.
jurisdiction to put there.
generally speaking, the only places, in my understanding, where NJDOT has said, no, we don't want sidewalks is on the limited access highway. So obviously, they don't want sidewalks on Route 55 or on the turnpike.
But they're putting them at 40 and 55, where everybody walks every day, all day.
Where? Yeah.
40 and 55, they're it's closed to do the intersection.
You mean 40 of me?
40 of me,
Yeah.
555.
I was like,
Well, no, there is the elementary school right there also. I don't know how many.
Yeah.
I don't know if they're done.
I don't know if the law is now.
I think
I
they're
know-
widening the intersections, what they're done.
And we should encourage open space and get trails where kids could bike.
Yes.
And myself.
I'll
Okay,
take it.
that would be safer too, to be off.
Yeah, I mean,
Okay, when is our next meeting?
Yes.
I'm afraid-
Well, today is Wednesday, but Wednesday's been working.
Yes, they have been.
So the month of April, what is today? Today's the third Wednesday of the month.
How about April 24th?
24th is perfect, yeah, for me anyway. The 10th is communications commissions.
Suzanne,
Back. I do.
can I ask you a question?
Sure.
I don't want to prolong this meeting, but I'm looking at number 14. That looks like a no discussion item. If we want to give that to Chris.
Oh, yeah.
So we can just check that off the list. And similar to 15, maybe Chris can come back with some recommendations for us on that.
Yeah, sure. On 14 and 15. then we
Neither one of
have-
those items really can be
Moratorium.
contentious items.
Right, exactly.
Steve, you got a, you okay with the moratorium or not?
No, I,
Not
tell
if
you
you
what,
put
I
something.
built in Vineland, and the engineer came up to me and said, Steve, you know, we're doing the road in 2 weeks. I go,
Right.
I got a house there, I'm waiting for the gas, your electric, you know, they have the electric. And he said, okay, 2 days. They had the gas company out there, and they did it, so that was them, because Vineland runs their own electric, so they could take it out.
They can.
That's tough, because you know.
Chris, let me ask you, on the moratorium, maybe this is an engineering question, but, I mean, is there strict compliance with that, or are there situations?
There's
Obviously,
always
emergencies.
situations, there's emergencies, of course, you know, you've got a sewer, well, you don't have sewer here, but if you had a sewer main break in the street.
Right.
You'd be able to open that, but yeah. For emergencies, yes, and there are, I can send you, this is one of the two suggestions Ed had to put in here. There are provisions or exceptions that can be made, that's not an absolute, but if you're building a house, and you want to put utilities in, you might have to open the road to do that, so it's not an absolute.
Yeah, I think if there's an exclusion for that, because in the township, I mean, the only thing we're talking about is gas service for opening, you know. We don't have to open the road here for anything else. But a lot of the mains are behind the.
They go on
behind
the
curb
sides,
lines now,
they
yeah.
go under, the electric was the problem.
Yeah.
Okay. I think we should, okay. At 15, I guess, as well, we could just get your recommendations, but we could, that one should be quick, even if we do postpone it to the next meeting. But- And then the 16th on,
They're all,
they're,
that's a deep discussion.
That's-
16 is a little bit longer, but it's,
yeah, great.
We gotta wait for our resident landscape architect, Jim Kelly, to be here to have this. Yeah.
Dutch Mill Swim Club.
Okay, well, we kept this informal, so I hope if anybody had anything else in the audience that they wanted to say or ask, do you have about like 1 minute?
Has detention and retention basins been discussed yet?
No.
yeah, we-
That's in the future, when we get to that, right?
Okay.
Yeah, I don't know that we need to discuss that in the master plan, because that's all, well, I don't know specifically what you're mentioning by that, but DEP has regulations on stormwater management that the township has to meet.
And they've gotten stricter with it as well, more recently,
I
so.
want to say that you just updated your stormwater management ordinance just last year to be consistent with the state requirements, as well as Pineland's updated theirs pretty recently as well.
Oh, I know.
So there may not be that much that we can address.
There's only one town I know of that's gone further than what DEP requires. I'm forgetting what town that is. It's not far from here, actually. I want to say somewhere in Atlantic County, just over the border, really. But I can find out about that if you're interested, because we were the engineers that wrote the updated code there.
Well, it'd be great, but so far I don't think our township has ever gone above and beyond the state rate minimums.
I mean, if you want to, you are allowed to.
Well, you can usually, you can often do more,
Yes.
yes.
Well, I was going to, I had something in my head up on Fry's Mill Road in Washington Township. I think it's a model for large-scale development, and just past the CVS at across Keys and
You're talking about Lumiere?
Fry's Mill Road.
Yeah,
The development that was put in back in the 90s that is
Yeah.
On the left.
on the left.
Lumiere.
Right down there.
Yeah, there's, is that what you call it? Yeah, there's no fencing. They can cut the grass, but you have to take enough space from the developer to have that kind of
Well, one of
a
them,
design.
I think when they started out, was basically, they sort of created a wetland, but
Mhm.
that's filled in tremendously. And the other one is still just plain grass, so I never quite understood what they were trying to do, and if it,
Well, it's not a hole. Like around here in our development, another development, you have a 15-foot hole and it's wet all the time and there's fence that falls down. And at least up there, it looks very nice.
It looks more
fits in,
natural,
and
yeah.
they have a nice buffer.
well, I think the rules really now that need to recharge the rainwater that lands on a site has led to more retention basins and getting the water to drain right away, so you don't have as many.
Right, and it has I think it has a concrete thing going through the length of it where, for the fallout, wherever it goes after that, but it's always dry, always dry.
Yes, because it
All I
soaks
can say
in.
to that, and I'm not the engineer, but the stormwater basins, you have to meet the minimum, either DEP or Pinelands regs, depending on where you are in town, and depending on how much disturbance you're doing, and the quality of the soils, and how deep you're going. And
That's
a few
not
other
very
things.
deep up there. What we have around here is
Well, I mean,
way too
You
deep.
you have to treat a certain volume of water, and if you don't have the space to do, an 8-inch deep basin across a large space, then they go deeper. It also depends on what the groundwater recharge rate is based on the soil. So there's a lot of things that go into it that may or may not allow that, whatever you're discussing to
Well,
happen.
if we're doing majors, that would be an ideal design to work into our major site
Well,
plan.
I think what we can actually put in the plan, I don't know that necessarily be recommending we revise the entire stormwater ordinance, but that we encourage a more attractive stormwater basin design that would be considered an aesthetic feature of a site rather than purely utilitarian.
Right.
I mean, treat them more like rain gardens rather than just a basin for storage of temporary storage of water. That much we can state in the master plan, and that comes into play when somebody's asking for any sort of variances. You can,
Right.
gives you a little bit of room to say, we'd rather see this be more of a rain garden with native plants.
Yeah, it
rather
has
than
buffers and everything. You can't even see the development.
Right.
It's got nice buffers and.
It would be, that'd be a nice addition to put in, yeah.
that's what I was
Anything else
gonna
from
be.
anyone? Otherwise,
Motion to close.
Motion to-
Second.
All in favor, say aye.